Welcome to Employment Law This Week. I'm George Whipple. Last week, Congress passed a bill addressing pre-dispute arbitration agreements for sexual harassment or sexual assault claims. Epstein Becker Green's Emily Patajo tells us what this means for employers.
The Act is in response to the Me Too movement, and it is very limited in its scope. It only impacts pre-dispute agreements to arbitrate sexual harassment and sexual assault claims, and in particular, the venue in which these claims can be litigated. The Act makes unenforceable any contract that's entered into before sexual harassment or a sexual assault claim arises. That would normally force those claims into arbitration. So unless parties agree otherwise, those claims must be litigated in court. The Act is very limited in that it only impacts sexual harassment and sexual assault claims. It's not retroactive, meaning that when the Act is enacted, it will only impact those sexual harassment or sexual harassment claims that arise on or after the Act is actually enacted. It also includes a delegation clause. So if there's ever any dispute as to whether the Act applies to a particular situation, case, or claim, in the Act, it already delegates those disputes to be handled by the court and not an arbitrator. There is a complex set of laws that govern arbitration agreements. Therefore, organizations should consult with their counsel and evaluate their existing arbitration agreements in order to determine whether any revisions to their arbitration agreements should be made.
Thanks, Emily, and thank you very much for watching. We'll see you next time.